Report with Sam Seder.
The destiny of America is always safer in the hands of the people than in the conference rooms of any elite.
Sam Seder.
They are unanimous in their hate for me, and I welcome their hatred.
We must guard against the acquisition of unwarranted influence, whether sought or unsought, by the military-industrial complex.
The Majority Report with Sam Seder.
Ever get the feeling you've been cheated?
It is Monday, June 27th, 2022. My name is Sam Seder. This is the five-time award-winning Majority Report. We are broadcasting live steps from the industrially ravaged Gowanus Canal in the heartland of America, downtown Brooklyn, USA. On the program today, Professor of Law at the University of California, Berkeley, Khiara M. Bridges, on the overturning of abortion rights and the expansion of rights for gun owners. Meanwhile, another decision dropped today. Supreme Court throws over the Lemon Doctrine to further crumble the wall between church and state. Meanwhile, polling has the Supreme Court in the dumps, and their decision to overturn Roe is opposed by over 20 percentage points. House gives approval to the Senate gun control compromise, now headed to Biden's desk. Oklahoma's permitless carry law has been a perfect answer to the question, how can we get more gun deaths in our state? New study, 79% of diabetics who rely on insulin have an average of $9,000 of credit card debt to pay for that medicine. Pfizer's study shows their new vaccine reported to be effective versus Omicron. G7 confers with Zelensky as Russia bombs a shopping mall with no apparent military involvement whatsoever. NATO now looking to increase their rapid deployment force by a factor of 8. And over the past year, more than 1 million people have switched from Democratic to Republican voter registration. 630,000 who have gone the opposite way. Iran and U.S. restart their nuke talks. And primaries tomorrow in Colorado, Illinois, and New York has some local ones. All this and more on today's Majority Report. Welcome, ladies and gentlemen. Emma Vigalind, still on vacation. I texted her the other day. I said, don't worry, you didn't miss anything big. Nothing big this week. I have to say, just for some reason, there are times like I don't even hear the music when it's playing, even though it's playing. Today, I heard it, and it just reminded me of the Boston show where Ted Leo and Combat Zone played not only that song, but a couple others, and still available in full to our members. If you become a member at jointhemajorityreport.com, you'll get access to that. And, in fact, our entire archive of shows over the past, 12 years. Getting on close to 12 years. So become a member today, jointhemajorityreport.com. There have been protests around the country in the wake of the overturning of Roe v. Wade and the subsequent abortion bans that have taken place that were triggered automatically in 13 states across the country. And we anticipate about another 13 states who are launching up their abortion bans. Here is two protesters This is out in front of the Supreme Court. This is on MSNBC, and they're smart.
So I received a text message from Joe Biden's campaign yesterday saying that the Supreme Court had overturned Roe versus Wade and that it was my responsibility to then rush $15 to the Democratic National Party. And I thought that was absolutely outrageous because my rights should not be a fundraising point for them or a campaigning point. They have had multiple opportunities to codify Roe into law over the past 20, 30, 40, 50 years, and they haven't done it. And if they're going to keep campaigning on this point, they should actually do something about it.
What are you most worried about, Jillian?
I'm most worried about what comes next because Roe versus Wade was a precedent for Obergefell versus Hodges, Loving versus Virginia, Irving versus Texas, gay marriage, interracial marriage, and privacy in the bedroom. And those, as Clarence Thomas came out yesterday, they're going to be falling like dominoes.
You come from Texas. You're in
Yes.
Austin, Texas. There's a trigger law in place in Austin in 30 days.
Yes.
Abortion's going to be banned in your state.
Abortion has been banned at 6 weeks in my state since last September, which is an essential all-out ban because most women don't even realize they're pregnant before that point. And there are women in Texas who've already died and have already been arrested for having an abortion or a miscarriage because we can't really tell that.
It seems like you have obvious anger towards the Democratic Party because you feel as if they've missed chances to codify Roe up until this point, and then here we are. What does that mean for you when it comes to the midterm elections and getting more Democrats elected to move forward with trying to codify Roe?
Well, when it comes down to the primaries, which I think are coming up in the next couple months, it means that we need to get as many people to the polls as possible to vote for more progressive Democrats. We need to get the old white Democrats out of office and put in new, younger people who will actually defend the rights of women and people all over.
I mean, both those women had far better awareness of what's going on than the reporter. And I would also argue everyone back in the studio and in the network. And I would say MSNBC is the most likely place where you would have people who would know something. And these two clearly know more than I would imagine everybody in that building for the most part. So it would also stand that they probably know more than just about everybody in almost every newsroom in the country. Chito Vela, a city council member in Austin, Texas, is trying to apparently organize a meeting on July 18th to promulgate the GRACE Act, where Austin city funds may not be used to investigate or report abortion. Austin police should designate abortion as their lowest priority for criminal investigation. There are about 80 prosecutors across the country who have said the same thing. I don't know if that makes a difference in the context of a city prosecutor versus a state prosecutor. And it really ultimately doesn't make it as important to do these things. And it's conceivable in a place like Austin, maybe you could have abortion services. But largely speaking, it's not going to be enough that prosecutors have pledged that they're not going to prosecute vigorously in the same way that exceptions to rape or incest or in the life of the mother also are going to have virtually no impact on the accessibility, availability of abortion services in these states where it's otherwise banned, because you're asking people to take a monumental risk, doctors to take a monumental risk. And I'm not justifying them not taking this risk, but it's just human nature. They're going to avoid doing taking this risk.
Many won't have the courage.
I mean, one of those protesters started to say, you cannot tell the difference between a procedure to rid the body of a miscarriage, either in terms of taking medicine or physically ridding the body of a miscarriage that has not passed, and an abortion.
I'm pretty sure they're coded as the same way medically.
I mean, you take the same drug, and The difference, of course, is that doctor could go to jail for 10 years, could pay a $100,000 fine. In Texas, I mean, the people who drove the person to the hospital, and on and on. So these aren't going to make that much of a difference. And they're important to do, but they're not going to make that much of a difference. We'll talk more with Khiara Bridges about this in a moment. She is a professor of law at the University of California, Berkeley. We also today had the Supreme Court case involving the coach who was assembling people after football games to pray to Jesus while on school time, essentially. The Supreme Court not only found in favor of his case, but also reversed the Lemon Doctrine, which was developed in a case, I can't remember, I think it was Lemon versus Kurtman. And this is one where the government can assist or basically countenance religion if three things are met. One, the primary purpose, or three things, one of the three things are met. The primary purpose of the government allowing for, you can pray on our football field at the high school game if the purpose is secular. Now, it's hard to argue that this is secular unless you're saying, like, well, it inspires people, but I don't think so. It should neither inhibit or promote religion. It does not seem to me that it promotes religion. I mean, that it inhibits religion. It certainly promotes religion. And if there is no excessive entanglement between church and state, the Supreme Court basically, the sixth majority basically said, we're not using that anymore. We're done with that. We will talk on Wednesday with Mark Joseph Stern about that case. And if the EPA case comes up, we will talk about that with him then as well. We'll get to Professor Bridges in a moment. First, I want to remind you, there is a special sale with two of our favorite sponsors. JustCoffee.coop right now has a 25% off sale on all their coffees. Use the code MR25. It's usually just the code majority, but today and for the next couple of days, MR25. You can try all of their different coffees. It's a great time to do it. It's also a great time to buy like a 5-pound bag. They're a co-op, fair trade, organic coffee, tea, and chocolate. Check it out. MR25, justcoffee.coop. And also, today is the last day. You now have almost 12 hours, a little bit less, to get 50% off hemp flower, smalls, and keef at sunsetlakesebede.com. Use the coupon code FlowerPower. Why? Because the sun is shining now, and the hemp plants, they are back in the field, and Sunset Lake Zebedee is kicking off their summer with a huge sale. From now until essentially 12 hours from now, 11:59 p.m., June 27th, all of Sunset Lake Zebedee hand-trimmed hemp flowers, smalls, and premium dry sifted keef will be 50% off with the coupon code FlowerPower. Matt is a huge fan of the smalls, and I got to say, I've been, rolling these occasionally for like an after-dinner type of aperitif.
You've been rolling your own?
Awesome. What's that?
You've been rolling your own?
Back in the day, I used to roll my own ciggies. Wow. And I can roll. I still have it. It's like riding a bike. And or sometimes I'll put it in a pipe. Nevertheless, it's a really fun, like sort of relaxing, mellow
ritual.
But also you get a little experience out of it. Sunset Lake Zebedee uses regenerative farming practice like cover cropping, crop rotation, beneficial insects to grow hemp flower without the use of harmful pesticides. That's called integrated pest management, folks. They also don't use synthetic fertilizers. The best part is they can ship these beautiful buds directly to your door in all 50 states. Sunset Lake Zebedee is a majority employee-owned business. They've donated more than 26 grand last year to anti-drug war organizations, animal shelters, union strike funds, nature conservation, food pantries, refugee resettlement organizations. They are genuine movement partners. They have a special coupon code this week, Flower Power, 50% off all the hemp flower, smalls, and keef. Of course, you also get Left is Best. You get 20% off of other things. Visit sunsetlakesebedee.com. Take advantage of these discounts. It ends tonight, 11:59. All right. Do we need to take a quick break? We're going to take a quick break. When we come back, we'll be talking to Professor Khiara Bridges, University of California, Berkeley, about the Roe decision and or Dobbs, I guess, and also the gun rights decision that came earlier in the week. We'll be right back after this. We are back. Sam Seder on the Majority Report. Joining us and welcoming back to the program, Khiara M. Bridges. She's a professor of law at the University of California, Berkeley. Emma Vigeland is out. Khiara, thanks again for joining us. We spoke, I guess it was just after the leak of Alito's brief in this case. And so this doesn't come as a total shock. But it's still shocking. And let's characterize for us what the difference was between Alito's brief and what the majority held in this case, and the brief that he ultimately wrote in the majority. And we should be clear, it was a 5-4. Break it down for us, because Roberts, well, maybe I've asked too many questions at once, but Roberts would have upheld the case for Mississippi in the 15-week ban, but would have basically just changed, I guess, Roe v. Wade in the same way that Casey sort of did too.
Absolutely. Yeah. So it was a 5-4, but Roberts certainly concurred in the judgment. 5 justices, with Alito writing the majority opinion, voted to strike down Roe v. Wade altogether. I think it's important to note that when Mississippi first petitioned for certiorari to the Supreme Court, when Mississippi first asked the Supreme Court to review this case, they simply asked for the court to get rid of the viability line. And that's what Chief Chief Justice Roberts would have done. And that's why he wrote a separate concurrence saying that all we were asked to do was get rid of the viability line. That's what I'm willing to do. I'm not willing. I don't think we need to overturn Roe v. Wade entirely. Now, the reason why the court was ultimately asked to overturn Roe v. Wade was because something had changed between Mississippi's filing of the petition for cert and the court's hearing of oral arguments. And that thing that had changed was that Ruth Bader Ginsburg died and Amy Coney Barrett was confirmed to the Supreme Court. So they asked for something bigger. They asked for a bigger ask, and that ask was to overturn Roe v. Wade. And and Alito wrote the majority opinion agreeing to do just that.
So, and do they, when they, is there a separate motion that they have to make if their search their initial ask has changed? Do they change in their they just update it in their briefs?
Correct. Yeah. So when they petition for cert, petition for cert is when they simply ask the court to hear the case. Hey, we have this controversy going on in Mississippi. We want to pass a 15-week abortion ban. Apparently, all the appellate courts are telling us no. Can you please, just hear this question about whether it's constitutional for us to pass this 15-week abortion ban? So the Supreme Court granted cert on that question, whether the viability line can be struck down and Mississippi could pass a 15-week abortion ban. By the time the briefs for they weren't the petitioners in that case, but they were the respondents. But anyway, by the time the briefs were filed, Amy Coney Barrett had been confirmed to the Supreme Court. And so when you read the sort of longer sort of argument about what Mississippi is making after they filed the petition for cert, that is when they make the argument that Roe v. Wade was, completely wrongly decided and ought to be reversed altogether.
Because it seems to me that we have a long line of cases. And in fact, I mean, and we're seeing it, and this has been the way that they've been working. We saw it in the case that came out today, the one about the Kennedy, the coach. We saw it even in the context of Citizens United, where there is a narrow question that is being asked, and this conservative court says this is a great opportunity for us to answer a much broader question, which nobody has asked, which is
it's certainly and.
Okay, I'm sorry. We're having a little bit of problems.
Or the court was initially asked.
Okay, I'm sorry. For one second. We just lost you for 1 second, but we can start again. Oh, she froze again. Okay, we need to go to a break, and for 1 second, and we'll be right back. We're back. Sorry about that, folks. Had a little bit of hiccup. I think we've got the problem fixed, more or less. So we were basically you were basically just talking about this inclination that the court has. This court, and I wonder if it's unique to a conservative-dominated court, because I don't recall other situations where. I guess maybe it would be the Warren Court, right, where you would get most of these, where somebody came and said, we just want the ability to have integrated schools, and the court says, okay, while we're here, actually, we should also change we should basically, reinforce the voting rights.
Right. Right. That hasn't happened. If you read the dissents in these cases, you will see the dissents sort of plead with the majority to answer the narrow question. There are actually all sorts of doctrines that the majority, conservative majority, could rely on to answer narrower questions. One is, just if there's a non-constitutional ground that a case can be decided upon, decided on the non-constitutional ground so that you don't have to get to the constitutional question. And so in case after case, you see a conservative majority skip over those kind of doctrines that would allow them to answer narrow questions and allow them to answer the big questions that they want to answer. But one other thing that's really important to note is that the court is capable of handling its docket, right? The court is able to decide which cases it will and will not hear. So the simple fact that the court decided to hear Mississippi's 15-week abortion ban case suggests that the court wanted to do something with Roe v. Wade. Wow. The simple fact that the case decided to hear the Harvard affirmative action case suggests that the court wants to do something with affirmative action. I can say the same thing about the New York gun case, right? The fact that they even heard that case suggests that they want to do something with regard to gun rights. So the court is shaping its doctrine so as to get at all of these issues that the Republican Party wants it to get to: guns, abortion, affirmative action, voting rights, so on and so forth.
And let's be clear too that Sam Alito literally had fever dreams about overturning Roe v. Wade as early as, or at least we have documentation about it from as early as the Reagan administration, where he was also in the Department of Justice, not unlike John Roberts, who had the same fever dreams about the Voting Rights Act. And all of their projects have come to fruition.
Right. I mean, Thomas has been screaming in dissent, for as long as I've been a lawyer about abortion rights, about how wrong this is. Amy Coney Barrett, when she was a professor at Notre Dame, signed an open letter where she said that Roe v. Wade was a travesty and should be overturned at the earliest opportunity. So they bought a full page ad on the New York Times. This is not just like some type of this was a full-on political advertisement for overturning Roe v. Wade. I mean, this has been the agenda. And of course, they could have touched the Texas case too, which was a sort of a de facto repeal of Roe v. Wade. So, okay. How does the brief that Alito, that was leaked, and I would argue probably by someone close to Alito, stack up versus the brief that ultimately was signed by the majority, whereas Thomas had like a concurrence that went a little bit further, but sort of harkened back to that first brief? Yeah, I think that in the first, the leaked draft opinion was even more skeptical of substantive due process rights than the ultimate decision that was released. In that sense, substantive due process rights are these rights upon which all of the rights that are important to marginalized people, LGBTQ people, people with a capacity for pregnancy, so on and so forth. We found those rights through the due process clause, and that doctrine is called substantive due process. The leaked draft was it demonstrated more skepticism towards that doctrine than the opinion that was ultimately released. And the opinion that was ultimately released repeated several times, if you read it like 3 or 4 times, that this case says nothing about our substantive due process cases, says nothing about contraception, it says nothing about gay marriage, it says nothing about the ability of states to criminalize same-sex sexual contact. And those sort of protestations just simply weren't there in the leaked draft. But I think it's important to note that for all the relevant parts were in that were in the leaked draft opinion, were in the opinion that was released on Friday.
How many subsidiary courts, circuit courts, courts of appeals, federal courts will cite the protestations that you should not apply those doctrines? I mean, in other words, I remember Bush v. Gore, and they said, I think they even opened their opinion with, don't ever cite this case. And it's been cited dozens of times.
Right.
And so once it's written, it starts to move in the direction of creating law and doctrine, regardless of, there is no do as I say, not as I do type of rule that exists amongst courts, is there?
Correct. And the dissent says just that. The dissent says you guys in the majority, and Amy Coney Barrett as well, you can say that this case says nothing about Obergefell, which, found a right to same-sex marriage. And you guys can say that this case says nothing about Lawrence v. Texas, which held that we have a right to consensual sex with adults. You guys can say this case has nothing to do with the right to access contraception, Griswold, but we know what you're doing. And it's the logic of this case that is devastating to all of those rights. It's also important to note the methodology that Alito uses. It's devastating to all of those rights. The methodology is originalism. And so the methodology of constitutional interpretation is originalism. And so what he's trying to do is divine, what did they have in mind in 1791 when they drafted the Constitution? What were the framers thinking in 1868 when they drafted the 14th Amendment? They weren't thinking about women. They weren't thinking about Black people. They weren't thinking about LGBTQ people. They weren't thinking about people with disabilities, right? So this method that Alito uses both in Dobbs, but also in the gun case, Brune, that method is just devastating. And devastating to marginalized people. And so what Dobbs does, even though it protests about this is not about Lawrence and Obergefell, that method that it rubber stamps, that it uses, when it's used by lower courts, when it's used by future Supreme Courts, it will lead to the reversal of all of these cases that are important for civil rights for marginalized people.
All right, I want to go through back through both those two sort of like I guess methodologies in which, and because the first, the substantive due process, this is essentially it's around the 14th Amendment. It is essentially like everything that we understand America to be up until really very recently has been a function of the 14th Amendment. More so than any other maybe clause in the entire Constitution. And
I happen to agree with you because I just happen to love the 14th Amendment. It has both the due process clause as well as the equal protection clause. So the 14th Amendment does a lot of work for us.
Okay, and so and just to remind people, this was passed in Reconstruction. It was in part part of the suite of amendments, I guess you could say, that was to address slavery and the sort of second-class citizenship of Black people at that time. There was a lot of negotiating because there was still Lincoln is dead at that point and Johnson is the president, and there's a lot of negotiating, and it wasn't as strong as it could have been. But so the 14th Amendment, explain how that has functioned, and just to be clear, what they do is they basically do two things in this case. They undercut how the 14th Amendment has provided protections for all sorts of people. And then they also construct a machine in which they can undercut, they put that in practice in some ways, where they will begin to undercut. They say, we're not doing this to undercut the rights of a bunch of other people, but there's the big machine that we just built. And so let's first talk about what the 14th Amendment has been doing for this country for 100 years. And then we'll talk about what the machine they're constructing to end all of that.
Right. Yeah. So the 14th Amendment has several clauses. One is the Privileges and Immunities Clause. Another is the Due Process Clause, and another is the Equal Protection Clause. There are a citizenship clause. But the big one is that, way back in the slaughterhouse cases, shortly after the 14th Amendment was ratified, the Supreme Court kind of nullified the Privileges and Immunities Clause. It kind of said that this clause is unimportant. And so that clause might have done a lot of work for us in terms of being used to find rights that are unenumerated, right? Not explicitly listed in the Constitution, but nevertheless are super important to people's dignity and equality.
Let me just stop you there too. The Ninth Amendment of the Constitution says that there are rights that exist. The people, it says, I think specifically amongst the people or within the people.
Reserved to the people, yes.
Reserved to the people, even if they're not mentioned here.
Right, exactly.
And so, let's just start with that. Like, how has that been interpreted in different ways? Like, in some instances, it just says, it's interesting because this is also going to have implications as to the way that we look at the way that the court sees the Second Amendment, which is in a totally different way. But how has that Ninth Amendment been interpreted?
So we have enumerated rights, and enumerated rights are those that are explicitly spelled out in the Constitution. So we have a First Amendment right explicitly in the Constitution to free exercise, to a freedom from establishment of religion by the government. And the Second Amendment, we have an enumerated right. It seems like I said, something about a militia, but we can get to how the court read that militia clause out, and it just says that you have a right to bear arms. So we have these explicitly enumerated rights in the Constitution, but the Ninth Amendment says, all right, even though we just explicitly named all of these other rights in these first 8 amendments, that should not be taken to be exhaustive, right? Like that is not a complete list of the rights that people have. The Ninth Amendment suggests that there are unenumerated rights, things that are not explicitly spelled out in the Constitution, but nevertheless are fundamental rights. And so it will be the task of the Supreme Court, the court, to determine what those unenumerated rights are, which rights are fundamental to people, such that the Constitution protects them with all of its might. The Ninth Amendment has been essentially overlooked entirely.
I mean, is there even an argument that the right has made as to why that we should ignore the Ninth Amendment? I mean, this gets to the whole heart of, it seems to me, of an approach towards the Constitution. Right, because it's almost explicit. It's not explicitly saying the Supreme Court has to come up with them, but somebody does. I mean, if the rights exist, somebody must acknowledge them. And the legislature, if it's a right, they really don't have to legislate on it because it's a right that exists. And
it's the right that the Constitution protects. Absolutely, yeah. So I can tell you, like, when I was in law school, it wasn't that long ago, we didn't even talk about the Ninth Amendment. Like, nobody takes the Ninth Amendment seriously. When you read these older cases, like Griswold versus Connecticut, which held that there is a fundamental right for married people to access contraception, which is kind of like the right that all of our reproductive rights flow from, arguably. In that case, it says, it comes up with a theory for finding fundamental rights that are not enumerated. It comes up with a theory for finding unenumerated rights. And it says, you know what, the Ninth Amendment might play a role, and maybe the 14th Amendment due process clause might play a role, but we're going to do this penumbral theory, which I won't get into. So courts in the past have gestured towards, like, maybe there's something there in the Ninth Amendment that's worth investigating, but nobody has taken it seriously. And I could, as a law professor, I would be foolish to devote time to writing an article about the Ninth Amendment simply because it's not going to be published, simply because nobody's going to take the argument seriously, because I have inherited hundreds of years of people overlooking the Ninth Amendment.
Well, maybe there's a movement, 20 or 30 years down the road when things change on the Supreme Court where we'll see that. But okay,
but I have to say, let me just interrupt you just to say, people used to make arguments about maybe there's an abortion right in the 13th Amendment. The 13th Amendment was the amendment that emancipated the slaves, right? It said, it forbade involuntary servitude. And people stopped making that argument, right? Because part and parcel of slavery was forced pregnancy. It was forced motherhood. So if that's a part of slavery, and if 13th Amendment ended slavery, then perhaps it ended forced pregnancy and forced motherhood as well. People used to make that argument. They stopped making that argument after the court ignored it, over the course of the last 50 years. Maybe it's time to start making that argument, because we can't make arguments for this court. This court doesn't care. We have to make arguments for the court in 20 years. Like, we have to make an argument for a court, because that's what the right was doing, right? The right has been making arguments that ultimately will be held, legitimate by a majority on the court.
Alito and Roberts, just two of them who were doing this as officials in the Reagan administration, and ultimately they came through. All right, so getting back to the substantive due process, you look at that and it says that how does one, and in my mind it goes through the Ninth Amendment, but how does one find a right to privacy in due process? How does one find a right to determine, whether one is going to carry to term an embryo and a fetus through their pregnancy? How does one find that you have the right to have consensual sex with anyone of any gender? It's up to you. Or you can marry someone from a different race.
Right.
Like, how does the due process come to that?
Right. Yeah. So the due process clause has been interpreted as protecting all those rights that you just mentioned through logic and through precedent. And I think it's so important for the audience to understand that the abortion right did not fall out of the sky. The right to an abortion in Roe v. Wade was built on a century of precedent. We all can go back to the 1920s when the Supreme Court interpreted the due process clause to protect a parent's right to educate their child as they saw fit, right? It's this case called Meyer versus Nebraska. It said that, if you want your child to learn German, then you can allow your child to learn German, because that is a parent's fundamental right to raise their kid as they see fit. There was another case, Pierce versus Society of Sisters, in the 1920s, in which the court said, if you want to send your kid to a private school, go ahead and send your kid to a private school. We can't make you send your kid to a public school. Want to know why? Because parents have a fundamental right to raise their kids as they see fit. So we have these, again, a century old, these cases that said that the due process clause protects a parent's right to raise their child. And it's just simple logic. By the time we get to 1960s with Griswold versus Connecticut, the court says, the right that we articulated way back in the 1920s about the ability to raise your kid as you see fit, that kind of suggests that you have a right to not become a parent in the first instance. And then in Eisenstadt in 1972, the court said, Griswold only applied to married people, but if married people have the right to avoid becoming a parent, then unmarried people have the ability to do the same. Skinner versus Oklahoma came along in 1942. The court said, if you have the right to raise your kid in the way that you see fit, that's what we said in the 1920s, then you probably have the right to become a parent in the first instance. So you should be free from coerced sterilization. You should be free from compulsory sterilization, right? So we have all of these cases in which the court was finding rights around the ability to become a parent, the ability to not become a parent. And then the Roe v. Wade simply said, well, if you have the ability to not become a parent by accessing contraception, then you ought to have the ability to not become a parent by terminating an unwanted pregnancy. And then Lawrence versus Texas, which struck down Texas's criminal sodomy law, making it a crime to have same-sex sexual contact. It built on these cases. It said that, well, this privacy right seems to protect, issues surrounding family and issues surrounding bodily integrity and decisional autonomy, and that seems to protect the right to have sex with who you want. And Obergefell built from there. So it's really just logic, right? It's really just, and that's judge it. Let me just be good. That's the judge's job. Like, your job is to use logic and reason and arrive at a decision. There's nothing illegitimate about that enterprise.
And we should say it starts with this initial premise that goes back, there's 100 years, at least 100 years worth of history that has been relied upon. And that's where, because there is a initial premise. If that initial premise had never been made, that the due process clause doesn't give a parent a right to send a kid to a private school, let's say, then maybe you would not get this lineage. But that's the whole point of stare decisis, which is that unless there is something, in what instances, and so, you've got 100 years of law that has been built upon this premise that was made, which I think you'd be hard pressed to find anybody who would say, like, you don't have a right to send your kid to anything. It's very hard for me to imagine supporters of this court accepting the idea that the government is going to force you to go to public schools regardless. Not just that you have to be going to school, but you can only go to public school. There is no parochial schools. There's no more private schools. You can only go to public schools. They would be screaming from the rafters.
I agree with you. I also disagree with you because it depends on which parent you are, right? So the parents, we saw parents lose their minds about perhaps their kid having to wear a mask in school, right? So it was all about parental rights. But we also should note that poor parents, the supporters of the court itself, have never been interested in protecting poor parents' rights to parent. So different parents, right?
Yes, fair enough. And so this law, so all of those things that you mentioned, if you were to undercut the reading of the due process clause, you could say, don't look at those things, but you've built essentially the scaffolding for this whole thing. And you said I built a little machine, and it is the machine that unwinds Roe v. Wade. And it is the machine that undercuts the due process clause, the substantive due process clause, finding these unenumerated rights. Well, you could turn that machine on any of those things at that point.
Absolutely. And again, the court says, you know what, we're not saying anything about those other cases. And don't listen to the dissent. They're just trying to scare you when they say that we've erected this machine that will undo your rights. We're not doing that. Abortion is the only right, or the right to an abortion is the only right that involves the destruction of a human life. And those other things don't involve the destruction of a human life. But I think that we have reason to be extremely skeptical of that statement, of that declaration, simply because of the logic of the opinion, because of originalism, because it undermines substantive due process. Another thing that I wanted to mention, which I think is super important, the liberals have done this as well, right? So in Lawrence, and different though, because we're interested in expanding rights, but in Lawrence versus Texas, which only involved Texas's criminal sodomy statute, the court said that there was a right to engage in same-sex sexual contact, consensual sex with an adult, and it said that that Texas law is unconstitutional. And Kennedy, writing for the majority, said, everybody thinks that this leads to gay marriage. Everybody's going to read his opinion, saying that this suggests that if there's a right to same-sex contact, then there must be a right to same-sex marriage. And Kennedy, in that opinion, said, we're not saying anything about same-sex marriage. A couple of years later, the court relied on Lawrence in its Obergefell decision, essentially saying that, well, actually, the right to same-sex sex leads to same-sex marriage. The same thing's going to happen here, right? Even though the court says we're not saying anything about all those other rights, the logic of the case leads to the overruling and the reversal of all these other rights that we hold dear as marginalized people.
And that is, that is the methodology of the law, essentially, right? I mean, that is what, I mean, that is bound to happen. And my issue with it is, I mean, I think, most people's issue with it is which direction it's going in, as opposed to so let's talk about the machine that they built and what they're calling it. And it is this new sort of, I mean, it's an interesting machine because it doesn't, the inputs and the outputs sort of change depending upon some special, magic that's in that box, right? So
it's an algorithm. It's an algorithm.
Yeah, and the algorithm seems to change depending on what it is, because talk about this, because he brought up what was it, Glux? I had it right here.
Washington v. Glucksberg.
Yes, please. Explain to us what Alito's sort of machine to diminish these rights is.
Well, describing it as an algorithm is actually pretty good because, a lot of times we don't know how algorithms work, and we don't know what the result will be. Alito's, and it's not just Alito, it's the entire conservative supermajority at this point, but they use whatever method they want to use in order to get the result that they want to get. And sometimes they do this originalist, argument. Sometimes they do a textualist argument, but in other cases they don't do it at all. In Brnovich versus DNC, there was nothing originalist or textualist, about the gutting of the Voting Rights Act and Section 2 of the Voting Rights Act in that case. So they're very selective with their methods that they use. But in Washington versus Glucksberg, the court was asked to determine whether essentially there is a right to end your life, if you are facing, a devastating diagnosis, if you're living in pain. And the court said, no, there's no right to end your life. There's no right to physician-assisted suicide or anything like that. Because, historically, we've just never recognized it, right? If we look at history and tradition, we've never protected this right to end your life at no point in our country's history. But that sort of investigation into history and tradition is a tricky exercise because we have to ask whose histories, history at what level of specificity, right? Because if we look at history, this is Loving versus Virginia, there was no right to marry somebody of a different race. What are you talking about? Like, it was all about white racial purity that was formalized in our systems. So if we look at history and tradition with a great deal of specificity, there's no right to interracial marriage. What are you talking about? There's no right to marry somebody of the same sex. There's no right to access contraception. Contraception didn't even exist, right? So this investigation into history and tradition can be deployed in interesting ways, because when the court wants to find something within this history and tradition is defined very broadly. But when it doesn't want to find something, it's defined very narrowly in a way that sort of renders obsolete or renders outside the right that, marginalized people hold dear again.
And so when they start to apply this notion of history and tradition, in this instance, they're looking back and trying to contextualize the moment in which the 14th Amendment is written and what was the ideas at that time. We should be clear, when the 14th Amendment was written, women were chattel of men. They did not have the right to vote. They couldn't practice law. They weren't allowed to have their own property. If you were married, you were the property of your husband. You weren't allowed to have your own money. I mean, frankly, my mother, when I was a child, a very small child, was not allowed to have a credit card in her name. In as late as the 1970s. I mean, so. Their argument is that short of the 13th Amendment, slavery would be A-okay in this country, right? I mean, they would say there is the tradition has been slavery is okay. And unless we have an amendment to the Constitution, slavery is okay.
Right. Yes. And that is absolutely the logical conclusion of that method. But so Alito spends a lot of time in the Dobbs opinion looking at the laws, around abortion in 1868, because that's when the 14th Amendment was ratified. And he's like, look, all these states criminalized it. Look, he has an appendix. All these states criminalized abortion. And of course they criminalized abortion. Women weren't voting yet. They couldn't vote for another 50 years. We needed a constitutional amendment to allow women to vote. So it's not surprising that laws criminalized activity that people with the capacity for pregnancy needed in order to be full citizens, because women were not full citizens in 1868. Another thing that's super important is that, even not looking at the law, if you look at norms, like the norms at that time were that if you could become pregnant, you were a woman. And if you were a woman, you should be somebody's wife. And if you're somebody's wife, you should be a mother. So gender norms in 1868 were such that, of course, sex leads to pregnancy, pregnancy leads to motherhood. And we didn't challenge those gender norms until the 1970s. So the method and this investigation into what was going on in 1868 is results oriented, right? Because it leads to a particular result where you're looking at laws that, of course, criminalize abortion because women didn't have a say in it. And that leads to a finding that there is no fundamental right to an abortion.
I mean, and I should say, Reva Siegel in the Washington Post, I guess it was 2 days ago, wrote, during the 19th century campaign against abortion, advocates for laws banning the practice argued they were necessary to enforce women's maternal and marital duties to protect ethno-religious character of the nation. And it seems, again, that like, if the tradition they're citing is one that is born out of the absence of political power by anybody except for white people, really, and really white men, well, explicitly white men, and arguably white wealthy men, because we're talking about the 1850s and, or I should say the 80s, and we're rolling out those literacy tests at that time that are snagging also poor whites as well as black men who wanted to vote. So it is, I've had these arguments with libertarians before where they talk about property rights. And the question is, when do property rights start? And just coincidentally, they start after white people come and take the property from indigenous people. Why do we start there? Well, it's inherited from the French. I mean, it's like, it's just sort of an arbitrary choice to look back into history and say, this is the normal time. The normal time was when women did not have the right to vote. And the way that our laws looked like at that time create the context in which we should interpret what rights exist today. But doesn't that lead to like a sort of an argument of, okay, we've very narrowly said women have the right to vote, but maybe they don't have the right to do other things politically in our, like, you can vote, but you can't necessarily serve in office.
Mm-hmm.
Yeah, I mean, it's an extreme, but it's the logic of what they're arguing.
Right. Yeah, absolutely. And, they would respond, well, if you don't like it, just pass the constitutional amendment. Like, if you don't like what the Constitution requires, just, put a new amendment in there. But we all know just how difficult that process is, and it's not a solution. Insofar as fundamental rights are supposed to be those things that we don't leave to democratic majorities. Fundamental rights are thought to be so important that we can't just say, hey, Texas, is it okay if I terminate this pregnancy? Or, hey, Texas, is it okay if I vote? Or, hey, Texas, is it okay if I marry this woman like I love her? Fundamental rights are supposed to be so important that we just can't leave it to democratic processes. And so then to say, well, if you don't like it, just amend the Constitution, is to throw it to the democratic process and ask for a super majority to affirm, your something that is essential to your dignity. And that's just simply not a solution.
Well, the good news is, though, is that if we apply this machine that Alito has constructed, where we must look at the context of the time, and that becomes the sort of the narrowest reading as to what is available. Certainly, when we have this case about the rights of New York State to restrict guns, this should be in the favor of those people who want to restrict guns, because at the time that the Second Amendment was written, guns were fundamentally a different thing than they are today in terms of like their killing power and both the distance they can shoot from, the speed in which they can, their capacity to kill people. A militia is obviously not an individual. And we also know at that time that if you went into Dodge City, you had to leave your guns out front. That people had permits that they had to get, or the sheriff could come to you and say, "I need your firearm if you're coming in to this place." So surely, when Alito applies that machine to the Second Amendment, it's in favor of gun control.
Right, yeah. No. So it's it would be funny if it wasn't so not funny. How the Thomas's majority opinion and all the opinions that came before, right, and Heller and City of Chicago versus McDonnell, how they allied what you just noted, which is that a musket is not a Glock even, right? To suggest that those are similar tools, weapons, is to look at it from a very, very general, a high level of generality. And the court has no problem doing that, right? It's saying like, well, the guns back then are essentially, there's both the same word, gun and gun. And so if we protected the ability perhaps to possess some sort of firearm back in antiquity, then surely you have the right to possess a Glock today. Again, a very high level of generality in finding similarity in those two things.
And so how is it, and we should say, so in this Brune case, essentially, the court found that New York State cannot require really anything in terms of permitting someone carrying around a concealed weapon. Like you can get a rifle to shoot, to hunt, you can do target practice, but if you carry the gun around for you for protection, you have needed to have a reason that you are sort of somewhat uniquely at threat because of maybe what your job is. Maybe you walk around with like, I'm a jeweler and I always have $25,000 worth of diamonds with me, or I don't know what the things are. And there was some argument that public defenders made who joined in an amicus brief saying this has been, there's been a racial disparity in the way that these permits are handed out. So we want to get rid of the permits. I would have argued to go for a different direction with that, frankly. But so where are we in terms of what a state can do? Because like Connecticut, for instance, they have, I know that they inhibit the sales of semi-automatic weapons, that unless you had them grandfathered in from like 30 years ago. What can a state at this point do or not do, and where are we headed with gun control laws?
Yeah. So all of the cases that the Supreme Court have held around gun rights, Heller, City of Chicago versus McDonnell, and now Brune, all involve handguns. So the court has said nothing about whether the Second Amendment protects a right to possess an automatic weapon, TBD. We have to watch. I mean, we can predict how that's going to come out, because if it's so funny, there's this moment in Breyer's dissent where he lists the weapons that existed in 1791. And I'm going to mispronounce them because I've never heard of them, right? It's a dag, a skein, a scalator, a launch-guy, right? These are things that we just don't know about because they don't exist anymore. That's what they were talking about, in the 18th century. That's what they were talking about back in England, which Thomas looks to in order to figure out, what we were thinking when we founded the country, what the framers were thinking when they wrote the Second Amendment. And so if your analogical reasoning is like a dag, a skein, a scalator, and a launch-gay is pretty much indistinguishable from a Glock, well, then how different is the Glock from an AR-15, right?
Right. I mean, this seems to me to be the case that you would want someone in favor of gun control to bring, which would be, I want to own a, one of those shoulder fired anti-tank missiles. Right. Like, why can't I have that? Why can't I have a grenade? would be far more effective if I came upon some toughies and they wanted to threaten me, I would throw a grenade at them. And so has the court, and I want to remind people, Heller was not in 1908 or 1808. It was in 2008. So this new right for an individual to carry, unfettered right to carry a firearm is, younger than my child, who's not even graduated high school yet. And so have they studiously avoided a challenge to a restriction on semi-automatic weapons, or frankly, like a tank? Or, I mean, arms is arms, right? Like, I read that we're selling arms to Ukraine, and it's not handguns. It's a bunch of other stuff. I mean, so I'm just being a textualist here.
Right. Right. So I can tell you that the Supreme Court has not granted cert on any challenge to a restriction on possessing an automatic weapon or a grenade or a tank or armor. And so the Supreme Court has sort of, like I've mentioned before, the Supreme Court controls its own docket. So there haven't been enough justices on the court. You need 4 to grant cert. There haven't been enough justices on the court who want to hear a challenge like that. When they have enough, they will hear it, and we can predict what the court will say the Second Amendment requires. One thing, though, I think it's really important to note that in all of those cases, Heller and the City of Chicago versus McDonnell, and now in Brune, the court says, we're not saying anything about the ability of a state to require applicants for a license to have a mental, a background check and make sure there are no mental illnesses there. And we're not saying anything about the legality of states to, not allow violent felons, who have a history of domestic violence to possess weapons. The court is saying, those things are legit, or we're not saying anything about their legitimacy. And Breyer points out, but if we're looking at 1791, none of those things existed. Background checks, making sure that violent felons with a history of violence against women or others, like that they couldn't possess a weapon, like that didn't exist in 1791. So if you are an originalist, if you are true to your method, you just lied. You just lied to us when you said that those things are likely legitimate.
It doesn't make any sense. And so when you say that we don't have 4 Supreme Court justices who are willing to take this, is that because they don't want to, they're not there in the, I guess, the progression to eliminate the ability for the state to issue any type of gun control? They don't want to get ahead of themselves. Like, are they afraid? Like, if, let's put it this way, if there was a 4th, let's say, liberal justice on there, might they be inclined to take that case so that they could test the consistency of the majority's perspective on this? I mean, of course, it would be 4-5, and I know that'd be a little bit dicey to do, and you'd be nervous about it, and whatnot. But and then alternatively, could someone in Texas say, well, I'm going to test this out right now. I want a Patriot missile. Or whatever it is, whatever the missile is that you can shoulder launch. I want one, and I want to be able to carry it around because if somebody cuts me off and I got to stand my ground. This is the best way for me to do it. I'm not a great aim, and I want to be able to take some stuff out. Could I go to the 5th Circuit and maybe hope that I'm going to do a little better there? They got to take the case, and they might put the Supreme Court in a position so that you might have 5 states where you could carry around like something like that.
Yeah, absolutely. So the way that I've learned that the Supreme Court, accepts these cases is through a circuit split, right? So we would need the 5th Circuit, probably the 11th as well, as where Florida is, to hold that. Actually, it is perfectly legitimate to have, a land-air missile, and any sort of restriction on your ability to possess a land-to-air missile, it's a violation of your Second Amendment rights. And then the 9th Circuit, that's where I am, Ninth Circuit and the Second Circuit likely will say, no, the Second Amendment doesn't protect your ability to launch missiles into the air. At that point, you would have a circuit split, and then the Supreme Court would be much more likely to resolve the conflict at that time. So these things take time. I'm sure they're working on it, but that's only if they want it, though. I think this is also super important. The GOP has to want it. The GOP, the only reason that we're talking about abortion rights is because the GOP wants to do away with it. The only reason why we're talking about affirmative action next term is that the GOP wants to do away with it. The only reason why we're talking about not limiting the ability of people to carry weapons outside of the home is because the GOP wants it. If the GOP wants people to be able to launch a missile into the air, we should expect it in a couple of terms.
And to be clear, the left, they attempt to bring up cases too when they think they have a sympathetic court. But the problem is that they don't have a sympathetic court now, and so they're not. These cases are not going to get heard. That's basically it.
Just going back to abortion rights, the due process clause is dead when it comes to abortion rights. It'll be really hard for even 9 justices, liberal justices on the Supreme Court to say, actually, Dobbs was wrong, Roe was right. It'll just very hard. It'll be hard for them. So likely we're going to have to make other constitutional arguments for abortion rights. I think probably, 13th Amendment, I super love. But, the Equal Protection Clause, like the ability, disallowing people with the capacity for pregnancy to terminate a pregnancy is an equal protection violation, because when women cannot, control what happens to their bodies, they're not able to participate equally in the life of the nation. So there's an equal protection argument. This court doesn't care about that equal protection argument, but what about in 20 years? Right. So liberal justices we might be able to see a reinvigoration of abortion rights via the Constitution, but it'll have to come through another sort of text, another part of the Constitution. And we should be planning now for that eventuality.
20 years, or do you think it's closer to 30?
How old? Thomas is kind of old.
Thomas is up there, but everybody else is.
And I don't think he wears a mask. I don't think he's masking up.
Yeah. Well, everybody else, I think Roberts is probably close to the oldest, and he can't be more than 50. What?
He's like 67.
Roberts is 67?
Yeah.
Oh, all right. Well, hope springs eternal. Professor Khiara Bridges, professor of law at the University of California, Berkeley, thank you so much for coming on and talking to us about this. I wish it was under better circumstances, but I have a feeling we're going to have more of these in the years to come. And
absolutely,
none of it's going to be good. We haven't even finished this round, and we still have West Virginia EPA coming out either Wednesday or Friday, probably, and that's also going to be
Climate change is a hoax. You didn't know?
I've heard such rumors. Appreciate it very much.
Thanks for having me.
Bye-bye. All right, folks, we're going to move into the fun half of the program, wherein we will have fun. Personally, it wouldn't work so much for me to bring that case in this circuit court because I would lose. But if I'm going to fight back against the government, if I'm going to have my arms to prevent tyranny, I need a surface-to-air, shoulder-mounted missile, because they're going to come at me with helicopters and probably some form of hover planes.
I mean, also the Antifa BLM guys have drones now, so we need surface-to-air missiles.
I need all that. In fact, I need one that will scatter a bunch of missiles, like a Patriot missile system. I don't need the exact same thing. I don't need the full Patriot missile system, but I need something like that.
Is anthrax an arm?
I mean, you can weaponize it.
I'd defend myself. The right to defending yourself. It's crazy. You can't even use anthrax on people that are going to attack you now.
I'm going to start carrying around my crossbow with the poison I got off the back of a toad. Right on the tip.
Shit.
Sorry, folks. But this, if they're I mean, this sucks. And we're not done. They're going to come out with West Virginia EPA, and EPA is going to be completely inhibited from dealing with climate change to the extent that it has been. But it's not just that. Again, they're constructing a machine. In this instance, it is a machine to undo the rights of essentially everybody who was not in charge of things in the 1850s and 60s and 70s. Well, really, to be fair, 1870s, right? Because you couldn't own slaves by the time these amendments passed, maybe 1880s. Couldn't own slaves, but just about everything else was fair game. Want to have a coup where you overthrow people and black politicians? That's okay. You want to inhibit people from voting because they can't read or they don't have a tax to pay? That's okay. You want to stop a state from saying that you can only have your workers work 60 hours a week? You want to stop a state from saying that children cannot be working 14 hours a day? I mean, I could go on and on and on. And this court is headed in this, well, I want to say it's headed in this direction, but in some instances, it's arrived. And, there's an argument for sure that Democrats should have codified this into statute, right to an abortion. I don't remember, many people talking about it. Even in, 2007, Obama said, this is the first thing I'm going to do when I get in there, which I think was a response to Clinton had been sort of backing off of abortion rights, just saying you got to be low key about it. And certainly the Democrats were afraid to push it. There's no doubt about it. There was a financial crisis, and there was some legislation that, ended up taking the priority, I guess, in 2009, I guess it was, halfway through. But nevertheless, they're not going to be able to do anything about this assault on the administrative state. There is no one single piece of legislation that you could pass. The bottom line is, we as a society gave the keys to the castle to the right wing in this country. That's what we did. And it's going to be a big slog to get them back. I don't know how else to express that. There's some stuff that if Democrats were to add 3 senators, I don't know, Fetterman, probably Ryan in Ohio even. I don't know who else, is even a slight pickup at this point.
You're going to have to replace the brains of about 50 people in Democratic leadership before they even think about doing something so bold.
Yeah, I think that's true. But the clock is ticking. And it's conceivable. It's conceivable that I think that, like, if you were to get 2 other Democratic senators, maybe even 1, you'd pull Sinema along, depending on how Mark Kelly does in Arizona, if he stays in there. And you could get them to suspend the filibuster, perhaps. I had this idea about putting a tax on abortions, like some type of, I guess you call it an excise tax, like like almost like a federal sales service tax, so that you could put it into reconciliation, because you can't have anything in reconciliation that doesn't deal with the budget of the government. But if you add a tax, you deal with how people pay for it later. But if you add a tax, maybe the abortion clinic pays the tax. You add a federal tax on abortion providers, let's say, for every abortion they perform. It would implicate the federal budget, it seems to me. But I've heard two things. And then you could pass and certainly having 26 states not ban abortion is going to increase your tax revenues. I've heard two responses to this. I don't know how valid they are. One is that you cannot create a new tax in reconciliation. You can only change existing taxes. I don't know if that's true. The other is that the parliamentarian may just see it as what it is a scheme to get a policy in there. But I don't know. Then you know what you could do? You could vote to overrule the parliamentarian, which George Bush did to protect the traditional American right for rich people to have lower taxes. That's when they fired their parliamentarian.
That's the thing, like when you listen to those two activists up top talk about, I don't want to hear about from the Democratic Party. And I do think, look, there's a way that certain pro-GOP people emphasize that to basically, demoralize people, right? But it is true, the Democrats can't be, effing around with this parliamentarian stuff and then still telling people, oh, but vote for us in November. Those sorts of things, there can't be status quo. There can't be, we're going to go down and robocall for Cuellar because he's an incumbent. You got to change operating.
Yep. And to the credit of those two activists, they were like, we need to elect more progressive Democrats. And the thing is that I think they are widely representative, those two, of their generation.
Yeah.
And which is not to say, I don't want emails that not quite boomers like myself, specifically Gen Xers, but also boomers and even the greatest generation, that there aren't people in those generations that have a good political perspective. But when we talk about the majority of those generations, I'm sorry. I'm sorry to all of us. 646-257-3920 is the number. If you want to call into the program, a reminder, it is your support that makes this show possible. You can become a member by going to jointhemajorityreport.com. When you do, you get the free show, free of commercials, except for today. We're going to do one more day because we get two movement sponsors. And we're going to keep both the special deal from justcoffee.coop with the MR25, 25% off, and the Sunset Lake Sabaday Flour Keefs Smalls on sale. Flour Power gets you 50% off. Are you kidding? Stock up, people. Stock up. Enjoy the harvest. That's what's happening right now. They're in the fields. God, I want to go up there.
Not far.
It's not that far. I should just drive up there. And also, become a member of the show and support a show that is so insisted upon having law professor after law professor on for the past 12 years. I got news for you. If you want to do a really popular YouTube show that generates a lot of views, don't have law professor after law professor on. But if you are interested in understanding the dynamics that are at play for the ability for us to exercise and have some of our fundamental rights and for the structure of government to remain as, we're a good show to support.
Which is, we're very close to something good there because there are a lot of law YouTubes, but it's like lawyers talking about the Amber Heard Johnny Depp trial, and they make hundreds of thousands of dollars a month.
Huge missed opportunity. They were just doing trial coverage.
Do you know how embarrassing it is to be talking to somebody and texting with people and they will say Amber Heard, and as recently as like 4 days ago, I didn't recognize the name. No idea.
Yeah,
I figured you
still
missed
kind
that.
of know who she was, but follow that trial. But yeah, I'm not.
I mean, I know who Johnny Depp is, of course.
Yeah, right.
And then I had heard about like his ex-wife had gotten like the ACLU helped write her something about, and then the idea of defamation that seemed a little spurious to me as well. But I don't know the details of the case, so I'm not going to opine on it. But I also had no idea who Amber Heard was.
I just know our channel would be about 3 times bigger if we had went all in on that.
Or even just, yeah. Well, there are search terms that people use, and all your YouTube folks have the ability. There's something called like the search gap or something like that now that they come out. And that is, what are people searching for? What's the unfulfilled searches that are taking place? And we use that tool just to come up with a sexier way of saying substantive due process clauses.
Yeah. West Virginia EPA case is important.
Right. Doesn't seem to be a search gap there.
Can you imagine a world where that got that kind of attention?
I mean, yeah, well, whatever. All right, 646-257-3920 is the number. We'll take your IMs. Matt, what's happening in the Matt Leckian media universe?
Oh, yeah. Andrew Perez of The Lever, we had him on to talk about Supreme Court dark money groups behind both the judges and the cases coming. That's up for patrons now, but we're going to release it for everybody tonight because it feels weird holding that out. So patreon.com/Left Reckoning if you want to get it right now.
Here is a IM from Avino. Keep talking dirty to me, Sam. All this talk of the invalidity of the Supreme Court is making me hot. Yeah, that's the way I roll. See you in the fun half.
3 months from now, 6 months from now, 9 months from now. And I don't think it's going to be the same as it looks like in 6 months from now. And I don't know if it's necessarily going to be better 6 months from now than it is 3 months from now. But I think around 18 months out, we're going to look back and go like, wow.
What? What is that going on?
It's nuts. Wait a second. Hold on for a second.
Emma, welcome to the program.
Hey.
Matt.
What is up, everyone?
Nomi Key.
You did it. Let's go, Brandon.
Let's go, Brandon.
Bradley, you want to say hello?
Sorry to disappoint everyone. I'm just a random guy.
It's all the boys today.
Fundamentally false. No, I'm sorry. Women's.
Stop talking for a second and let me finish.
Where is this coming from, dude?
But dude, you want to smoke this 7A?
Yes.
Hi, me? This is?
Yes.
Is this me?
Is it me?
It is you.
Is this me? Hello, is this me?
I think it is you. Who is you? No sound. Every single freaking day. What's on your mind?
Sports. We can discuss free markets and we can discuss capitalism.
I'm gonna go throw up.
Libertarians.
They're so stupid, though.
Common sense says, of course.
Gobbledygook.
We fucking nailed him.
So what's 79 plus 21?
Challenge Matt.
I'm positively quivering.
I believe 96, I want to say.
857-210-501. 1/2.
9/11, for instance.
$3,400, $1,900.
654 $3 trillion sold. It's a zero-sum game.
Actually, you're making me think less of it.
But let me say this. Poop.
Call it satire. Sam goes at satire.
On top of it all, my favorite part about you is just like every day, all day, like everything you do.
Without a doubt. Hey, buddy, we see you. All right, folks.
It's just the week being weeded out, obviously.
Yeah, sun's out, guns out. I don't know.
But you should know.
People just don't like to entertain ideas anymore.
I have a question. Who cares?
Our chat is enabled, folks.
I love it.
I do love that.
Look, gotta jump. Gotta be quick. I gotta jump.
I'm losing it, bro.
2 o'clock. We're already late, and the guy's being a dick.
So screw them. Sent to a gulag?
Outrageous.
Like, what is wrong with you?
Love you. Bye.
Love you. Bye-bye. We are back.